Hello, my name is Attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston. And I am back again today to answer all of your Illinois family law matters. So today's question is, my soon-to-be ex just got a large inheritance. Am I entitled to any of that? So, because you said it's your soon-to-be ex, I am presuming that there is a divorce case that's pending, and therefore your ex would not voluntarily like to share his or her inheritance with you. So let me tell you about divorce law. In a nutshell, what a divorce case does is it divides the marital estate. And so in order to divide the marital estate, which is comprised by marital debts and marital assets, the court first has to determine what debts and assets and income actually gets included in the marital estate prior to the division. Inheritances are notoriously and explicitly and specifically non-marital. And so even if your soon-to-be ex-spouse receives an inheritance, it is non-marital, even if that inheritance was received during the course of your marriage. The only reason why an inheritance would be transmuted from a non-marital asset to a marital asset is if, for instance, your ex put the money in a joint savings account or some way commingled the non-marital asset with marital assets in a way that is not traceable. If there was significant commingling going on, then you can make the argument that the non-marital asset then got transmuted and changed into a marital asset, and therefore you could lay claim to it. Generally speaking, this isn't going to happen, especially because you've asked about your soon-to-be ex. During the middle of a divorce, she's probably not going to get a piece of property or an inheritance from her mother or from her father, and then be so careless as to put that money in any account that has your name on it. So the answer to the question is generally no. But that's not the end of the story. Let's talk about what you can do and how an inheritance, which is non-marital clearly, can still be used for purposes of this litigation. What the courts will use an inheritance or any other asset, any other income for, is generally for purposes of calculating an equitable amount of child support, maintenance, college contribution, so forth and so on. So any type of financial obligation of the parties. A court will also consider marital and non-marital assets and accounts, including an inheritance, when determining what the division of the marital estate should be. Example of this. In college contribution cases, if you scroll through my videos, I've done a specific video about college contribution and the factors that need to be shown and considered by the court. So the court's not going to necessarily only be looking at income of the parties. The court will also look at the relative access to assets that each party has. And so if you have one parent in a college contribution case that is sitting on a large pile of money, they have a nest egg provided to them by way of an inheritance, that's absolutely going to be considered by the court when determining who should contribute what towards college for their children. Additionally, when we talk about dividing a marital estate, an example of that would be if you have spouse A and spouse B, and spouse B inherited, a significant sum of money from his or her parents. Spouse B's inheritance, although it is non-marital, and so it won't just be divided down the middle, it won't be divided in any way, shape, or form for purposes of writing a check out of that inheritance to give to the other side. The court will consider spouse B's inheritance when determining whether or not that spouse should get an equal portion of the marital estate or whether or not there should be some sort of a deviation. Because remember that Illinois is a marital property state. And so in a marital property state, such as Illinois, the court is not going to just necessarily equally divide all of the debts and all of the assets. The court will do an equitable or fair division of the debts and the assets, which means that the court will consider all of the income, all of the debts, and all of the assets in determining what a fair division of the marital estate is. Maybe spouse A, who does not have a nest egg and doesn't nearly have access to the resources that spouse B has because spouse B inherited, Spouse A might get 70 or 80% of the marital estate, leaving spouse B, who has an inheritance to fall back on, only gets 20% of the marital estate because that's all they really need in comparison to spouse A. So while it's a non-marital asset, always, inheritance is always, the starting point is that it is a non-marital asset. It can definitely come into play, even if it is not proven to be commuted into a marital asset. It can always come into play in litigation in this way. I hope that this has been helpful and informative, and I look forward to seeing you on the next video.